There's a single-story office building in Wilmington, Delaware. Yellow brick, a faded red awning, a small parking lot. It's the registered legal home of more than 285,000 companies. Apple, Google, Coca-Cola, Walmart, American Airlines. The same building housed entities tied to both Hillary Clinton and Donald Trump. In Delaware, even America's most theatrical enemies can agree on one thing: a nice, anonymous mailbox. Not one of these companies has as much as a desk inside, which, given the tenants, feels like something of an oversight. A Dutch firm runs the building, Wolters Kluwer, which started out selling school books in Groningen in 1836. The most American address on earth administered from the Netherlands, which makes perfect sense. If anyone was going to figure out how to house 285,000 companies without paying for a single extra chair, it would be the Dutch. How is it legal, and why does it work, and what happened the one time it stopped working? Well, that's just one building. Across the whole state, Delaware's the registered home of about 2.2 million companies, and there's only about 1 million people who live there. Paper residents outnumber people 2 to 1. Delaware is less a state than a multi-billion-dollar filing cabinet that just happens to be burdened with keeping the streetlights on. The building's not a scam, it's not a loophole, it's a storefront. Delaware sells a product, and the product is a legal fiction. A thing's paperwork can live in one place while the thing itself lives somewhere else. In the United States, the law that governs a company comes from the state where it's incorporated, not the state where it operates, not the state where its employees work, the state where it files its corporate paperwork. Lawyers call this the Internal Affairs Doctrine. In practice, it means a company gets to pick its own legal home, and most of them pick Delaware. If you're going to guess why, the most obvious and reasonable guess would be tax-related. And you'd be wrong. Delaware's corporate income tax rate is amongst the highest in the country. What Delaware sells is predictability. The Court of Chancery has been deciding corporate disputes for over 2 centuries. Specialist chancellors hear cases without a jury, because nothing threatens a highly structured corporate strategy quite like having to explain it to 12 ordinary people. The precedent is deep, fast, and public. A boardroom can read a chancery ruling and plan around it for decades after. That's the product. This corporate franchise brings in about $2.2 billion a year, which is more than a third of the state's entire budget. In 2024, Delaware incorporated 81% of every company that went public in the United States. And all 1209 North Orange Street actually does is accept legal papers in the post. A Delaware company needs a Delaware address so a court can contact it. A GAO investigation around the turn of the century found that one registered agent office in Newcastle, Delaware, handled 708 corporations per receptionist, a professional oversubscription rate surpassed only by the likes of Bonnie Blue. So, a mundane mailbox, 708 companies to a receptionist, and $2.2 billion a year. What does that machinery actually produce? Well, it began as a poaching job. In the late 19th century, New Jersey rewrote its incorporation laws and made them as permissive as possible in order to lure companies out of New York. And it worked. Corporations flooded in, and New Jersey collected the fees. The muck-raking journalist Lincoln Steffens branded it a traitor state. New Jersey thought they had a monopoly on the corporate hustle, right up until Delaware stole the playbook in 1899 and figured out how to do it without an accent. Then something happened that no one in Trenton saw coming. Woodrow Wilson became governor of New Jersey in 1911 and tightened the corporate laws. He wanted to clean the place up. The businesses left. They went south to Delaware, which had been waiting with the identical permissive statutes on its books. Woodrow Wilson eradicated New Jersey's corporate monopolies by effectively buying them all a train ticket to Wilmington. It remains one of the greatest philanthropic acts ever performed for a state he didn't live in. The legal fiction started with copied legislation. It became absolute. For nearly 2 centuries, a Delaware corporation didn't even have to state what it does. No description of business, no line on the annual report saying, "We make cars" or "We run hotels." Just a name and an address. It wasn't until recent federal crackdowns on anonymous money forced Delaware to update its paperwork that the golden era of silence ended. Now, 2 million shell companies are legally obligated to formally declare to the state that they're an AI-powered B2B SaaS platform disrupting the synergy space. Because of this race to the bottom, the company on your high street is governed by a state you've never visited. It answers to a court with no jury you'll ever see, and until 2026, it didn't even have to say what it does. But the real legacy isn't just Delaware. It's the fact that every other state in America was forced to lower their own standards just to compete. That's the legal fiction at work. There's a legal principle called Escheatment. It says that when property goes unclaimed, a dormant bank account, an uncashed check, a forgotten deposit, it goes to the state. But if the company doesn't have your address, it doesn't go to the state where you live, or the state where you lost it. The money defaults to the state where the company holding it is incorporated. Which means Delaware keeps America's forgotten money. For years, it was the state's third largest revenue source, somewhere between $400 and $500 million a year. Delaware operates much like a municipal sofa cushion, quietly absorbing the nation's loose change and refusing to give it back. Delaware got so greedy with this loophole it ended up in the Supreme Court. In 2023, Delaware v. Pennsylvania, a fight over MoneyGram's unclaimed funds, Delaware tried to claim uncashed money orders from other states just because MoneyGram is incorporated in Delaware. They fought it all the way to the Supreme Court and then lost. They were apparently stunned to discover that finders keepers is not, in fact, a registered doctrine of constitutional law. But that ruling covers one company. The broader machinery is still running. A dormant account at a firm incorporated in Delaware still escheats to Delaware. That forgotten money's legal home isn't where you lost it. It's a filing cabinet in a state you've never lived in, held by a government with no particular obligation to come and find you. That is the legal fiction at work, and this time it has your name on it. Toys R Us had a mascot, Geoffrey the Giraffe, a children's character, very friendly and recognisable, and as it turned out, a tax structure. The company took its trademarks, including Geoffrey, and put them into a Delaware subsidiary called Geoffrey LLC, a shell with no real operations. Its only job was to own the name. Then the stores in other states, the ones with the shelves and the customers and staff, paid royalties back to the Giraffe, licensing fees for the right to use a brand they already owned. Those payments were tax deductible in the states where the stores operated, and in Delaware, where Geoffrey LLC sat, there was no tax on the income it received, because Delaware completely exempted income made from intangible assets like trademarks. Every Toys R Us in America was in effect paying rent to a giraffe in Delaware. The giraffe paid no tax, took no meetings, and existed only on paper, which, apart from the paper part, makes it largely indistinguishable from most retail executives. Money moved from states where things were sold to a state where nothing happened, routed through a fictional character in a filing cabinet. And it's a pattern. Home Depot did the same thing with a subsidiary called Homer TLC, a holding company with about 4 employees whose job it was to own the brand. 4 people, 1 brand, and not a single hammer between them. To be fair, and this matters, many states fought back. They passed add-back rules that forced companies to add those deductible royalty payments back into their taxable income at home. A lot of this was clawed back. The loophole is not as wide open as it once was. But the structure still tells you something. A store in your hometown can quietly send its own profits to a cartoon giraffe in a state where it has no office, no warehouse, and no customers. The store pays rent, it pays staff, it pays local property tax, but to use its own brand name above the door, the store has to pay rent to a filing cabinet in Wilmington. That missing tax revenue was supposed to fund your community, but on paper, that money wasn't made in your town. It was made by the giraffe in Delaware. That's the legal fiction at work. It's a small amount of money per store, but multiplied across every main street in America, it's the reason your local government says it can't afford to keep the library open. There was a company in Delaware called Euro-American Corporate Services, which doesn't sound dodgy at all. It formed about 2,000 shell companies for Russian brokers out of a rented mailbox that a representative visited just once per quarter. The rest of the time, nobody was there. It's the ultimate remote work success story. But over time, those shell companies and the 236 bank accounts they controlled laundered roughly $1.4 billion. The operation was a high-speed funnel bouncing money from Moscow to New York to Latvia in a matter of hours. And it didn't stop there. In the late 2010s, when billions of dollars were looted from the Malaysian sovereign wealth fund known as 1MDB, the money ran through 8 different Delaware LLCs. It bought a yacht, it bought a Van Gogh, and in a detail that would be rejected from a screenplay for being a bit too on the nose, it financed the production of the film The Wolf of Wall Street. Stolen Money financed a film about stolen money. The most authentic prop on the set was the film's own budget. Paul Manafort used Delaware entities. Michael Cohen used Delaware entities. Backpage, the classified site shut down by the federal government over allegations of facilitating sex trafficking, operated through a Delaware LLC. The vector here is always the same. Not the people caught up in the fraud, not the people trafficked, the address, the structure, the filing system that accepted them all, kept them in good standing and never asked what they did. It is the same system that holds Apple, the same statute, the same registered agent model, the same good standing, a blue chip company and a sanctions evasion pipeline filed the identical paperwork and at the identical kind of address, and the system treats them identically. The system didn't fail to notice, the product is a system that was never built to look. And the one law meant to fix this, to end anonymous shell companies in America, was the Corporate Transparency Act. It passed, it took effect, it required companies to report their real owners to FinCEN. Then the regulators reconsidered. In March of 2025, FinCEN exempted all US-formed entities from the reporting requirements. The domestic shell companies, the exact category the law was written to cover, were removed from its scope. The law meant to end anonymous American shells now applies to foreign-formed companies only. They solved the problem by legally redefining them as none of the government's business. The legal owner on file isn't who you can actually find, and the one law meant to fix that was repealed by the people it named. That's the legal fiction, and at this depth it has no face at all. In early 2024, Delaware's own court ruled against the richest man alive. That ruling would end up not surviving, but the reaction to it is the whole story, so hold on to that. Musk told founders never to incorporate in Delaware again, and a parade of names followed him out. TripAdvisor, Dropbox, Roblox, Coinbase, The Trade Desk, all reincorporated, mostly to Texas and Nevada. The headlines called it DExit, except the numbers say something else. In aggregate, Delaware grew. Entity registrations were up through 2025. It still incorporated 81% of US IPOs. The departures were real, it just was made to look worse than it really was. It was effectively the corporate equivalent of announcing you were leaving Twitter. A handful of loud accounts made a big deal about storming off, while 2 million others just started Xing rather than tweeting. A few billionaires made a point. The machine just didn't notice. This isn't a story about Delaware breaking down. It's just a story about what happens when the richest man on earth gets told no by a judge and enters what his biographers call demon mode, which is just the billionaire equivalent of a toddler tantrum. But what Delaware did next is where it turns. Now, to be fair, incorporating in Delaware isn't a crime. It's not suspicious, and it's not evidence of anything. Most of the Fortune 500 are incorporated there, and nearly every US company that goes public picks it too. If you run a company of any real size, incorporating in Delaware is the ordinary, rational, defensible thing to do. And we need to untangle the 3 mechanisms we've just looked at: the corporate courts, the tax loopholes, and the shadow companies, because they're not the same thing. The first is incorporation itself. The Court of Chancery, the deep precedent, the predictability a boardroom can plan around. That's a legitimate product. It works because it's good. The second is the Intangibles loophole. The cartoon Giraffe, the 4-employee entity moving $2 billion a year. That was real, and much of it has since been curbed. States fought back. Add-back rules did that. The third is the anonymity layer. The shell companies, the ghost offices, the filing system that never asked what it was processing. That is the genuinely dark one, and it's not the same thing as a Fortune 500 company choosing a predictable court. So let's grant all of that. It's ordinary, it's legal. Most of the companies at 1209 North Orange Street are there for perfectly rational reasons and have done nothing wrong. That is the point. It stays ordinary and legal because the state will rewrite its own rules to keep it that way. Delaware's entire pitch, the whole 2-century sales job, is the predictable court. The expert chancellors, the deep precedent, the system that lets a boardroom plan because the rules don't change under your feet. In January 2024, Chancellor Kathleen McCormick did the most predictable thing that the court has ever done. She applied its own precedent. When she looked at Elon Musk's $56 billion pay package, she found that he acted as a controlling stockholder. Under Delaware law, if you control a company, you are legally required to prove that any massive payout to yourself is completely fair. But she found that the board who approved it was just stacked with his personal friends. The process wasn't independent. He couldn't prove it was fair. So the court did exactly what 225 years of case law demanded. It voided the package. $56 billion, the largest compensation awarded in corporate history, gone because the product worked exactly as advertised. And it worked for about a year, because the same court system that took it away gave it back, twice. First, the state wrote a new law. We'll get to that. Then, before the new law even had to do the work, the Delaware Supreme Court reversed the decision on its own. In December 2025, it ruled that cancelling the package had been too extreme a remedy, and restored it. But note what the High Court didn't do. They didn't say the process was fair. They didn't overturn the finding that the board was conflicted and full of his friends. They left the wrongdoing completely on the record. They just took away the consequence. The final penalty for the largest conflicted pay deal in corporate history was reduced to exactly $1. It turns out getting a pay package roughly equivalent to the annual budget of the entire United States Marine Corps, verified by the state of Delaware, is actually cheaper than getting a blue verified checkmark on X. That is a problem. Corporate law exists to stop executives from looting their own companies. But if the state proves it's too scared to actually enforce those rules against a billionaire, then anyone with a pension or a 401k has absolutely no protection. The rules are just suggestions. Musk called for an exodus. A handful of companies answered. We've seen the list, and rather than stand by its own courts, Delaware surrendered. In March 2025, Delaware passed Senate Bill 21, which opponents dubbed the Billionaires Bill. The bill redrew the line for who counts as a controlling stockholder. The old standard was functional. If you controlled the board, you were a controller, and you had to prove your payout was fair. The new threshold is 33.3% of voting power. Elon Musk held roughly 21% of Tesla. Under the new law, his pay package would have gone through without scrutiny from the court. Musk had already left for Texas, but by rewriting the dictionary, Delaware made sure that what he got caught doing is now perfectly legal for any billionaire who stayed. They no longer have to prove their deals are fair. And as long as the payout is approved by their billionaire entourage or board of directors, the court can't stop them. The bill also trimmed the two sharpest tools shareholders had. Section 220 governs the right to inspect a company's books and records, the mechanism that lets an investor see what actually happened behind closed doors. The state narrowed it. Section 144 governs conflicted transactions, the rule McCormick's court had just applied. The state softened that too. The sponsors framed it as clarity, predictability, a modernisation of corporate law to keep Delaware competitive. In February 2026, the Delaware Supreme Court upheld the bill, and they confirmed something else. It reaches backward. The politicians who wrote it swore it wasn't retroactive, and technically, if you'd already filed a lawsuit against a billionaire, you were safe. But if they broke the rules before the bill passed and you just hadn't filed the paperwork yet, the new rules protected them. They successfully moved the starting line backwards in time. It's the legislative equivalent of altering your report card while your parents are already reading it. To save a product built on an independent court, the state made the court less independent for the people most likely to be sued. One more structural point, and it is structural, not an accusation. Delaware has no rule restricting the corporate defence bar from drafting legislation that directly affects its own clients. The lawyers who defend controllers in Chancery can write the statutes themselves. It sets the limits on what the court can do to them. There is no prohibition, there is no disclosure requirement, there is no recusal. It's a highly efficient system. The people who stand to lose the most in court are allowed to edit the rulebook. That is the system, not an allegation about who did what. It's the absence of rule. The Harvard law professor, Mark Rowe, put it plainly, years before any of this happened. That which persists in Delaware is that which the federal authorities tolerate. Widen it one notch. The product persists in whatever shape the powerful allow it to take. And here, in under 2 years, a court applied its own law, a billionaire objected, and the system undid it twice over. The state rewrote the statute, and the state's highest court reversed the ruling. The legal fiction didn't break, it adapted. The distance between a thing's paperwork and the thing itself is still there, but now the rules governing that distance are written by the people it protects. The building is still there, yellow brick, faded red awning, the same small parking lot. It doesn't feel absurd anymore. It's the honest storefront of a product, the legal fiction, that an entire country buys, and that the state will defend by statute. When the state rushed to pass a bill protecting corporate boards from lawsuits, they didn't say they were doing it for the billionaires. They sold it on jobs, on teachers' pay, on first responders. The argument went like this. The corporate franchise brings in more than a third of Delaware's budget. If companies leave, the money leaves. If the money leaves, the teachers go unpaid. And the franchise really is that large, more than $2 billion a year. But Delaware caps the franchise tax at $250,000 per company. That means even if a $1 trillion company leaves, the state only loses about $250,000. So on one analysis, and this is an analyst number, not a neutral fact, each departing company dents the state budget by about 0.0036%. It would take hundreds of departures to actually threaten the state's budget, but only a handful left. To protect a revenue stream of an exodus of hundreds, the state responded to an exodus of 6. They didn't need a real crisis. A hypothetical one worked just fine. It is a perfect paradox. The franchise revenue is undeniably vital, and the threat to it was exaggerated to pass a bill that mostly protects the people least likely to need protecting. In March of 2026, a former chair of the Delaware Economic and Financial Advisory Council, the state's own budget forecasting body, asked a question on the record. Michael Horton wanted to know why the reconciled franchise revenue numbers had been withheld during a period when the state was publicly touting a surge in incorporations. Days later, the state removed him, by email, because obviously looking a man in the eye while you fire him for doing his actual job would have been too confrontational. When the reconciled numbers finally came, at a meeting in May 2026, the franchise revenue had grown about 1%. They gutted the power of their own courts to shield billionaires, all to prevent a budget crisis that was entirely made up. 2 honest things before we stop. The aggregate data on companies leaving Delaware is contested. Some analysis shows a meaningful shift. Others show the state still growing. The headline exodus and the real aggregate are not the same number, and which one you trust depends on how you count. And the claim that SB 21 was drafted by lawyers tied to companies it protects is reported by credible outlets and even legal scholars, but it's not proven. It's an allegation, and it should be treated as one. But the sequence is not contested. A court applied the law, a billionaire complained, so the state changed the law. The highest court gave him his money back and then upheld the new rules, and the man who asked to see the numbers was fired by the people trying to hide them. That is the legal fiction. The paperwork lives in one place. The thing itself lives somewhere else, and the distance between the two is maintained by the people the distance best serves.